There's been a lot of discussion, of course, about the proposed settlement agreement in the community since we completed the negotiations on the compensation in June 2012 and the more or less completed the text of the proposed settlement agreement in 2013. For example, people ask, what does this compensation cover? What are we being compensated for? And the answer to that is it's not sale of land, it's not purchase of land, not purchase of your land interest. What you're being compensated for is the breach of fiduciary duty by the federal government, and specifically, the elements that go into the compensation are the loss of use over the whole period of time since these claims began. Some of them, as I said, are over a century old. There's the present value of that land as just bare land, okay? Not what buildings are on it, but just what would the land be worth, plus interest. And of course, that was a big part of the negotiation, because whatever interest rate you apply and how many years you apply it over and how many acres are involved adds up to, that multiplication determines how much the compensation is. So we had hard negotiations on those matters. Did we agree to quieting of title? And what happened on that is, yes, in these, well, I should say, what happened on that is no. Typically, in this kind of agreement, the federal government requires what they call quieting of title, that you promise never to try to exercise your rights with respect to the areas that in question, and renounce all interest in those areas. And we had instructions from Chief and Council as the process went on that we would not agree to that. So we've got unique language that says, no, there's no quieting of title. We have agreed, and this is normal because there's no place in Canada where people have had privately held lands handed back to them. We have agreed, or we would agree in the agreement, that the private owners can continue to exercise whatever interest they may have in the lands now. But we also have specific language that says we can continue, or Listigouche can continue to exercise Aboriginal treaty rights and Aboriginal title in those areas, and any dispute is left up to later negotiation or later litigation. Some people have asked, well, how does this proposed settlement agreement relate to our comprehensive claims negotiations for Giskabawagi? Now, these are two separate processes. They're related in the sense that they both deal with issues of land and rights, but as we've said, the specific claims that are in this settlement are only with respect to small areas, and the agreement is specifically without prejudice to the comprehensive claims negotiations that could come in the future, which are being handled by the Mi'kmaq Maui-Omi. Some people have asked, well, it's related, can we sue for Aboriginal title and get more of the land back? For example, Man Fraser. There is certainly nothing in this agreement, in fact, it specifically preserves the right to sue over Aboriginal title. And there would, if that was successful, then there would be certainly monies and lands which would come back. But there is no case, and the Chilcotin case in BC is a recent example, that case specifically excludes private lands. There's no case that we're aware of in Canada where private lands were returned as part of a comprehensive claim. So yes, the comprehensive claim and the suing for Aboriginal title would still be alive and viable, but of course you're not going to get doubly compensated. You can't say, well, now that we've been compensated in the claim in this settlement agreement for the loss of use of those lands, we now want to be compensated again for the loss of use of those lands. That would be double dipping, which wouldn't be possible. One of the questions people have been asking about the proposed settlement agreement is why, when it all started with Bastide, are we now settling, or why does it roll 5 different claims into one? That is the Bastide lands, the Highway 132, the interprovincial bridge approach, the Mission lands, and the Man Fraser estate lands. And the answer to that is that it's not a question of the claim or the case having morphed from being the Bastide claim only to being all five. What happened was that in 98 it would have been, the late Donnie Germain went on to the land, which was the Bastide estate, and took out loads of sand to build houses on reserve. And at that time, Bastide brought an injunction in the Superior Court of Quebec to stop that incursion into what he regarded his lands, and to claim damages of $250,000 against the band, members of the band, the Jigood Corporation at the time, the tribal overseers, and various individuals. And all of those people made a counterclaim saying, look, we don't owe you, you don't have a right to your injunction, and we don't owe you anything because in fact you're not on your own land anyway, that you don't have proper title. So that case, the Bastide case, was in the Superior Court. And the federal government was drawn into that, and was pretty worried about it because it was a challenge and to the established order, if you like. And so that case was going along. And then what happened in 2003, and of course I should back up and say, for many, many years, and we'll talk a little bit more about that history in a while, but for many years, Listigouche had been doing research with legal people and with historians and with Mi'kmaq experts, elders and language speakers and so forth on the various land dealings, which are often known as specific claims, in and around Listigouche, and preparing to make the case that there had been wrongful action by the federal government, or what we call breach of fiduciary duty, failure to protect the Mi'kmaq lands. So in 2003, we brought the case that is now being proposed to be settled in the federal court. And the reason it was brought in 2003, and the reason it gathers together 5 specific claims, is this. In 1993, Quebec got a new civil code. And in that civil code, the limitations periods that would apply to cases, not to an Aboriginal rights case or an Aboriginal title case or a treaty case, but to a case about breach of fiduciary duty, which is like a civil wrong. It's a wrong, it's kind of thing that you could sue your neighbor about, except in this case the neighbor is the federal government. That in those cases, the limitations periods for taking an action to court were shortened. And many would say, well, why? Quebec law doesn't apply to us. But in fact, the Supreme Court has held that in that kind of case, in a fiduciary duty case, the law and limitations of the provinces does indeed apply. So we advised Listigouche that the LMG at the time, that we should, to safeguard the rights, commence a case and stop the clock running in the limitations period. And so we were given the 5 claims, which were fairly well advanced, fairly well documented, to include in that lawsuit in order to miss the deadline, or no, sorry, in order to beat the deadline, I should say. So that's how we ended up having the 5 cases. And so it was never a case of the Bastide case changing into the 5 claims. Now, it is true that as part of the wider negotiation, there have been 2 stages. The first stage, we did indeed settle the Bastide case, and those lands, as everybody knows, very important lands for Listigouche, were added to reserve in the end in 2000. Well, the case was settled in 2009, and the lands were actually added to the reserve in 2012. But the other thing that people are saying, well, originally we were offered $21 million for Bastide, and now you've settled for $64 million for everything, for 5 claims. Well, let me set that record straight on that as well. There was never any offer of $21 million for the Bastide claim. There was an initial offer of $21 million from the federal government to settle the 5 claims. And that is what we have now negotiated up to the $64.5 million compensation. some people are saying, well, is this a land claim settlement? Well, it's not a land claim settlement. Under federal policy, and it reflects a reality as well, there are two kinds of things. There's specific claims and comprehensive claims. Specific claims have to do with dealings of land. Somebody stole my land. Somebody was supposed to, or the government was supposed to give, 1 square mile and a mule and a plow to each family and a sack of grain or whatever it was, or this much ammunition, and we never got that. So we want to settle that issue. Or our land was stolen by the church, and the whole series of those kinds of very specific transactions. Whereas a comprehensive claim has to do with the idea of what we call common law Aboriginal title, the idea that even though when the Crown arrived and claimed sovereignty over all of Canada, basically, that interest of the Crown, the common law says, and it is a common law doctrine. It's not something. It's not necessarily the Indian or the First Nation point of view. It's part of the laws of the colonial law, if you like. But the colonial law nonetheless said the interest of the Indians or the First Nations, Aboriginal people in their lands is something that is maintained and can only be given up to the Crown. You can't, Tom, Dick, and Harry can't come around and occupy land, or, Tom, Dick, and Harry from England or from the United States or from the American colonies can't come and just occupy your land. They have to first, the Crown first has to purchase or get the cession of that Aboriginal title before it can be available for settlement. And in Atlantic Canada, including here, we're under what are called the Treaties of Peace and Friendship, which there was never any giving up of Aboriginal title. So the idea would be that there's still existing Aboriginal title, and of course now the treaty rights as well, the relationship of the Treaties of Peace and Friendship. And it's that idea of an underlying interest in the lands and the resources throughout the territory that is dealt with typically in a comprehensive claim process. It's not about specific parcels, and the typical result of a comprehensive claim is some kind of definition of the rights, or people call it certainty today. It used to be called extinguishment. So it's a controversial matter whether you want to go down that road. But you then usually typically get a large amount of monetary compensation and access to certain lands and resources, not necessarily just specific lands, like in this case, Cross Point. So this litigation and this settlement is not about that big issue of land claims or rights throughout the territory or the treaty rights. It's about these specific dealings. Basically what happened was, since the arrival of the loyalists in the 1780s, that's those who left what became the United States, the Listigouche people have protested against the fact that their lands and resources have been taken over, and especially with respect to dealings in and around Listigouche. And the basic theme that we've been complaining about is that the Crown failed in its obligations to protect the Mi'kmaq, even though they promised to protect the Mi'kmaq and say, well, we won't allow people to settle on your lands or in your hunting territories. And that promise was in the Royal Proclamation in 1763. That promise is part of the context of the Peace and Friendship Treaties, which stretch from 1725 through to 1779. Basically, the last ones were made here in this territory. And so there were over those years, lots of letters and petitions and surveys and trips to Ottawa. I think 2 trips to London, England by Mi'kmaq from Listigouche to try to protest over what had happened. And in the 1970s and 80s, there were some cases decided in the Supreme Court, the Calder case, which was the first Nisga'a case, which recognized that Aboriginal title existed as a doctrine in Canada, didn't find that the Nisga'a had Aboriginal title. And then the Guerin case in 1984, which is the first case to say that the fiduciary duty, and a fiduciary duty is a duty that arises when somebody has a responsibility who's relying on them, or they say, well, we're going to protect you. A typical example would be obviously a foster parent with regard to the minor that they have charge of, or in this case, the Crown saying, look, we're going to protect you. And what the Supreme Court said in 1984 was this fiduciary duty is not just a moral obligation, but it can give rise to, it can give you a right to sue for breach of fiduciary duty and get damages or compensation in the courts. And so that's where that happened in 84. And after that period, you get all of this research on specific claims, and in this case, the Listigouche people started researching the Mann-Fraser claim, the Bustede claim, the Mission Lands claim, the approach to the interprovincial bridge approach, and the 132. So maybe we should just talk a bit about what the case is and what the case isn't. In 2003. In order to beat that deadline and also to move the issue forward, beat the deadline of the limitations period, but also to move the issue forward, there was an opportunity to say, look, the specific claims process is broken. There's a huge backlog. Let's take it to court instead. And the results are the proof of the pudding is in the eating. Specific claims are constantly being slowed down and rejected, whereas we have gotten to the point where, after 200 years, we got the federal government to the table, and they've now negotiated what we think is a pretty good settlement. Of course, it's not perfect because it's a negotiation, and the federal government wants certain things that we have to give them the satisfaction that these issues are not going to come back again. So we don't get everything we want. People would like to have more money. People would like to not have to give up on these wrongs and say now they're settled. But it's got better language in it and better protections for the wider and longer term interests than any other deal that I'm aware of in Canada.